All right. Welcome everyone to kind of a Ask Me Anything. I don't think attorneys like that, but
Yeah, I think my marketing team freaked out when they first saw that. Like, what?
they were like, can you change all of this work? And I'm like, absolutely, 100%. Um, all of those things. But I will let our guest introduce herself and then we'll get started with whatever questions you all have. We'll keep it informal. We'll be here about 30 minutes. But go ahead, introduce yourself.
Yeah. Hi, I'm Jenna Grady. I'm healthcare regulatory counsel, which means attorney at Nixon Peabody, a nationwide law firm. We have around 600 attorneys. I'm co-chair of the behavior health practice group at Nixon Peabody. Prior to being an attorney, I was with the Arizona Department of Health Services Division of Behavior Health, which no longer exists. It was gobbled up by Arizona Medicaid. But during my time there, I worked on the first behavior health integration RFP for Medicaid managed care for seriously mentally ill population. And it was quite exciting to see, behavior health integration in 2010, which is like so long ago now. I'm like, oh gosh, but we're still trying to figure behavior health, physical health integration out. So hopefully eventually. So yeah, that's how I got into the behavior health space. And when I first started out being an attorney, it wasn't, people were like, oh, you don't really focus on behavioral health law. And then COVID happened and everyone, attorneys, investors all decided, oh, maybe we should focus on this. Maybe it's actually, people are not okay. So glad that it's finally getting the recognition it deserves, that the brain is part of the rest of the body. And very happy to be here today and answer any questions people may have as they're an employee, independent contractor for mental health platforms, or if they're just thinking about starting their own mental health platform or having a side hustle.
The floor is open.
I came with like a specific question, so I'll jump in. Thanks for doing this, Jenna.
Of course.
So my question, I have a very tiny private practice and I just have it's a sole proprietorship. I'm also starting to do some consulting for health tech startups. And I guess my question is, throughout this process, I've kind of called it's a private practice and consulting business. Is there any downside legally to having those be part of the same business?
So I would say, think about it. Oh, and I should have done marketing, would have been like, Jenna, you need to remember to say this.
Disclaimer, not legal advice.
I am not being engaged by anyone today. Feel free to call me after and have a discussion and yeah, maybe potentially engage in the future. But this is just general legal advice, and yes, consult with your own attorneys if you have them. But yeah, stuff you should be aware of. So with that said, Hannah, think of it possibly you can definitely have it in the same entity or with your sole proprietorship. One thing you may want to think of is liability wise, as your counseling business grows. If there's any liability or obligations with your counseling business, do you want that all tied to where your professional services are also being in that entity? So would it make sense to just set up a new LLC for your consulting? And that way, any liability, obligations, taxes can just be in that one separate entity as you grow your consulting.
So the main kind of thing I should be thinking about is liability, because you're right, I have liability coverage for my private practice, but it certainly does not extend to my consulting services.
Yeah. And you probably want separate liability insurance, so all of that figured out, because your malpractice insurance carrier will definitely be like, well, we're not covering that. So
right. And so if I get a separate liability policy for my consulting services, you're kind of saying my life might be easier if that was just a fully separate entity instead.
It could be, yeah, okay, depending on your discussion with your insurance broker.
Okay.
Their thoughts were.
Okay. Well, thank you. That was really my main question I was showing up with.
Good enough.
That was a great question, Hannah. And also to that point, do you think, I'm trying to ask this question the right way. So Hannah is a psychologist, and Washington State.
Okay.
Do the laws matter when you are consulting organizations that are not in your state, but then are also like building out like national platforms? I'm wondering if there's like a insurance policy that kind of covers that.
Yeah, I mean, that's a great question. So as long as you're providing consulting services, and definitely look at who's engaging you. Usually with these mental health platforms, it's the back office entity that's engaging consultants to ramp up their platforms, and not the actual professional entity. So if you are providing services to that, back office entity, then you don't have to worry about, okay, am I providing clinical services in this new state? If you're being engaged by a clinical entity, and if you're thinking some of the scope of services are like, this is getting really towards like direct patient care, then yeah, definitely consult with an attorney or someone, or your state bar, or not state bar, your state association, and figure out if that's something that you're like, this is getting scope creeping to clinical care, and maybe I would have to be licensed or subject to licensure in that state.
I have another question that it's not really a question, but I just wanted to get maybe your thoughts on about like reviewing agreements. When founders or co-founders of mental health startups are like, I want you to advise me or consult, what are the different kinds of agreements we should have? Like, I know that I'm using like some example, I think the FAST agreement for advisor, but then like there's all kinds of different contracts and agreements that we should be like looking out for based on the services that we're providing.
Yeah, so like usually with these mental health platforms, you have a basic standard, either independent contractor agreement or advisor agreement, like you said. Things you need to be looking out for in those agreements. Yeah, what are exactly the scope of services you're providing? What leeway you have in providing services to others. Frequently, we see some, non-solicitation, confidential information. What do they consider confidential information? Some of the key points you have to think of is there should be something in saying you will not disclose confidential information, saying that anything that's publicly available is not considered confidential information. Or anything that you have to disclose by law is something that is not subject to the restriction to disclose confidential information. Look at compensation. Who are the parties? And yeah, but definitely seeing those types of agreements populate as everyone gets an advisory board and wants assistance.
Anyone else have any questions? I'll just keep going with things that people ask me. And
well, I have a quick question, and it might not be relevant for this chat, so happy to defer elsewhere if needed. But I've heard some discussion on the clinical front around with SIPACT, becoming more and more of like, folks are being licensed in multiple states. Do you have any resources that you could point us to around considering taxes for, or just like legal, information in general beyond like, we would need to know mandated reporting, for example, in each of the relevant states?
So that is a great question. And I'm actually working with the ATA, American Telemedicine Association, the mental health subcommittee as a subcommittee, working on a SIPACT handout 101, what you need to know when you're joining the SIPACT and when you're providing services to multiple states. And one of the things we are looking at is, like you said, mandatory reporting. It's different in every state. I recently had a clinical provider for one of our mental health platforms have an issue with a patient. Patient said something, and based on what the patient said in like 10 states, that wouldn't have to be reported. In 10 other states, it would have to be reported, just like that one sentence. So it's significantly challenging sometimes. But we're definitely working on a handout. I think they want it to be out later this year. But yeah, that was actually one of the points I told Jacqueline I wanted to make on like these state by state duty to warn, duty report, mandatory reporting requirements. It's definitely a handful.
Okay, thank you. And I'm really happy to hear that resources are coming out around that. And I would assume that maybe working with a tax advisor around like the business, you know, the business tax side of things is probably the recommendation.
Mhm.
Okay. All right. Thank you.
Mhm.
Cheryl, do you have any questions before I ask a question next?
Thank you for asking. Yes, the context of my question is, with the recent layoffs and a lot of the situations happening at startups, I'm thinking a lot about work agreements and kind of advocating for therapists in the community. Are there things that you would recommend, we look out for when we are reviewing kind of our offer letters? Just kind of, your general take on things that we can do to support each other and kind of prepare, knowing the landscape that we're in.
Yeah. So thinking about also the landscape, the Federal Trade Commission recently had proposed rules that basically blew everyone away, saying we think non-competes should basically be prohibited. The final rules of that will be coming out soon, we think. But that could definitely change like the competitive landscape of this if employment agreements with their non-competes are considered no longer permissible. I would definitely say when you're at the offer letter stage, certainly take it to attorney within the state that you are located in. Sometimes with these, just any business, they're going to, depending on their resources, they're going to determine, okay, this is what we want as a non-compete, non-solicitation, without actually maybe having an attorney review it and tell them if it's even enforceable, or B, having an attorney in all the states they're in review based on each state law, whether that's enforceable. So Cheryl, you could be based in Texas and get an offer letter from a company that's based in Arizona and could have very different non-compete, non-solicitation laws. So just because it's in contract doesn't mean that there's not wiggle room, especially for those provisions. And there's also companies that they know their non-competes, non-solicitations aren't enforceable, but they also know that a lot of contractors, employers, they won't perhaps actually engage an attorney to ask if this is enforceable. They'll just comply with it or think, oh, there's no wiggle room for this. So definitely feel free to engage an attorney and have those discussions, or have discussions with the company itself if you don't want to get an attorney involved and be like, do you really need this, state restriction for this non-compete or whatnot?
Great, thank you.
Yeah, my question was kind of similar to Cheryl's. I was just wondering, like, as more people are getting laid off and as more of the digital health companies are kind of shuttering, like, how do clinicians, how can they better arm themselves? Or even if an attorney finds something in the agreement that's not right, what do they do? What do they say?
So if you so if you want to keep being engaged, employed, and you did hire an attorney, they're like, no, I don't believe this is enforceable. Feel free to reach out to HR and have that conversation and just say, hey, I like being here. I want to be here for X amount of years. I don't know if I want to be here for the, considerably for long term, but you're definitely able to have those candid conversations. Would they change it? That's HR's legal standpoint, but you can definitely have those conversations. But obviously, yes, it's better at the beginning when you're negotiating to figure that out than when you're engaged or employed.
I have one other question I see. Sorry, I'll go back to you. I kind of see this frequently come up in therapists and tech is around contractors versus W-2. And I feel like the regulations around that are kind of evolving and it's a little hard to keep track of. So I guess I would love to just kind of hear your take on like what should be legally the differentiators between a W-2 position versus a contractor position. And just kind of things that therapists should be on the lookout for if they get offered a position as a contractor, but maybe there's would be the indications that like, actually, this should be a W-2 role.
Yeah, that's a great question. So this is like an IRS question and also a state by state analysis. So the IRS has its own list of elements of what they consider is an employee versus a contractor. If you're being required to do like 40 clinical hours, then you're likely an employee. You're not going to be a contractor. If they are really restrictive on how you provide services, that is a factor that it weighs more to you being an employee than an independent contractor. If you get a set, salary, that's going to be you're an employee versus a contractor. Again, at the offer stage, if you get something that you're like, I'm being offered this as an independent contractor, but it feels more like an employee situation, feel free to engage an attorney. Or if you are currently an independent contractor and you feel like you're an employee and you've had conversations with your the person that you're engaged with, the platform or other entity, and you're not getting any headway, there's certainly state resources. You can contact your AG's office to review. You can contact the state's employer and divisions and whatnot. So there's definitely resources out there to review and to analyze on your behalf whether you're being misclassified as an independent contractor.
And let me ask that from the reverse perspective too, because some of the companies I advise are grappling with this, particularly in that they want to hire contractors who are part-time, maybe working kind of, a range of like 5 to 15 hours a month. But one of the things you said, right, is it depends on how much control the company takes over how you practice.
Mm-hmm.
That's a lot of companies have trouble finding that line of like, what does that mean? Of like, because most companies have a particular way that they're to approach treatment, not but many. And so like, where is that line of what they could kind of say like, well, this is how we do it at this company. And we want you to use our system to write your notes. And we want you to, like where, I don't know, anything that you've seen in terms of those operational implications of what it means to hire contractors.
Yeah, like I think especially in the mental health platforms, it is so hard with employee independent contractor distinctions. And it really is a state by state analysis. And it's like Uber Lyft. Like, are Uber Lyft drivers independent contractors or are they employees? I felt like they were employees, and that's how things sort of hashed out for a while. So yeah, it's really, and again, it's going to be a state by state analysis and what your platform feels comfortable with. And some companies are willing to take the risk of misclassification. Some are not. Your bigger platforms, they have a more robust legal team, and they, the issue or the more likely of whistleblowers to say, hey, I'm being misclassified is more significant than a new startup. So yeah, unfortunately I don't have a great answer of like, this is an independent contractor, this is an employee.
That's good to know that at least it is a gray area legally and that there's so much difference state by state. I think that's also super interesting. Okay, thank you. That I just hear a lot.
Anyone else? I have a question. I want to know, so a big part of our jobs as clinicians when we're in private practice is kind of advocating with insurance companies for like bringing our rate up. do you have any thoughts or like, like how is this like, are there other ways that maybe we don't know about that we can be advocating like legally for us to be paid at least a Medicare rate? Like, have you seen anything about this or?
Well, yeah, it's so hard, especially because you only have so much data. But I would say any data you can provide and any measurements you can provide, because there's a lot of, especially now with so many mental health platforms out there and just mental health telehealth providers, everyone's saying you should include me in your network, or you should increase my reimbursement, and payers are like, why? That's their question. Data is king. Obviously, provide it in a legally compliant way, depending on whether or not you're regulated by HIPAA. Not all providers are. So yeah, the data sharing, saying I look based on this de-identified data, I'm able, my patients have done XYZ. Again, I know like clinical based measurements and what is a good measurement for mental health is like something we've been talking about for years and still haven't figured out. But that is my little helpful advice. I know it's so hard with payers, especially as small startups or small, just like independent practices.
Another question I have is what I'm starting to see as like some of our companies that we saw that like exploded in the height of COVID 2020 are closing, and I'm starting to see this push for acquisition of group practices. Any thoughts on acquisitions of these group practices, or any thoughts on like how clinicians can better protect themselves when these companies are shuttering their doors or their company is being acquired? Any thoughts on that? Like things that do contracts become void? Like how does that happen? Like what happens?
So yeah, that's a good question. I'm trying to. So if like you're a practice that is providing services for one of these mental health platforms and they just go.
Yeah. Or like, for example, like Hannah and I worked for a company that is defunct as of this year. Like there were tons of therapists that were working there. You know, how do they protect themselves from like clients filing claims against them at the bar? I mean, at the bar, but the state board saying, "Oh, I got abandoned by my therapist," but in all actuality, this company actually
Yeah.
had acquired or they sold them the materials of the company or whatever.
So yeah, definitely follow your state's guidance for patient termination and provide those letters, emails, what you can. And the company hopefully would be one that would help you with that. I know not, you know, there are some bad actors. Also notify your malpractice carrier and just say, as a heads up, this company is I'm no longer able to provide telehealth services. And I don't know, you know, I'm trying to reach out to patients. I may or may not be successful. So that if potentially a patient comes with a claim saying you abandoned me, you've already provided your malpractice insurance carrier notice that this could happen. Because at the end of the day, like any insurance, and this is going to sound cynical, but this isn't illegal advice. So they don't want to pay claims, and they'll figure out any way. And like in any situation, anytime you get a gut outside of this scenario you gave, anytime you in your gut, you're like, ooh, this didn't end well, or this patient seems not too happy with me. Send a note to your insurance carrier. Like there's no harm to sending them a note and just putting it on their radar so they can never be like, well, based on this Yelp review that you made a comment, which by the way, you should never leave comments on Yelp reviews because that can be a privacy violation. But in case you did, they'll be like, you knew about this. Why didn't you tell us? So yeah, covering that way. Fortunately, I'm assuming these contracts, they're probably not very well protected for the clinician, some of them on, you know, you're just out of luck. But yeah, definitely notify patients based on your state licensing board guidance.
That was good. I never thought about that. Thank you for that suggestion.
Of course.
We have a lot of people getting laid off in our community right now, and a lot of people are affected, and I just want to make sure they can protect themselves. Any last questions or thoughts from anyone else? I was just going to ask Jena to just leave us with any highlights, any things we need to be aware of on the legal front that maybe we have not thought about or heard about. I know the Surprise Act or law went into effect, like things like that. Like, are there anything that clinicians should be thinking about right now?
So I will say, ChatGPT, I know I've been talking to so many people that are just now using it as part of their day-to-day. And be careful with it from a privacy standpoint. So anything you put in ChatGPT is not private. It's going out there in the universe for all to see. And I just don't know if people fully understand that it's not just staying in a ChatGPT box for you and it's not going out there for all. That's why Italy recently just banned ChatGPT until they figure it out. They're just like, whoa, from a privacy standpoint. And Europe's always, from a privacy standpoint, usually one step above the US on trying to like be as, robust privacy protections as we can. So just be cognizant of it. Not all AI is bad AI, but just, I don't think we know that the significance of ChatGPT yet. And yeah, definitely from privacy. And I would hope mental health platforms are providing heads up info on that. I don't know. I haven't talked to any of them about it. And yes, large language learning models. Absolutely, Jacqueline.
Yeah, I had to check myself the other day. Like I use Grammarly in a lot of things. And then don't get me in trouble, but I was writing a note in Simple Practice and I was like, Grammarly is here. I'm like, I have to take it off. It can't read my notes.
Yeah.
I was like, oh my God, don't do that.
Yeah, and looking at these privacy policies for some of these websites, they're huge and long. I get that. Also, another note, if you're starting your new company, don't copy and paste terms and conditions and privacy policies from other companies. Like they spend a lot of time on those and they're very specific to them. And you don't want a patient to be like, well, you say in your privacy policy that you do X, Y, and Z. I see some out there that I'm like, there's no way you do this. But so yeah, definitely the ChatGPT is something. And I'm actually on the subcommittee for ATA on ChatGPT and what we think moving forward when we're meeting at 2 today to start that like handout for patients to actually understand what it is and what the restrictions, limitations are. It's all fascinating.
Well, thank you. This was great. So happy I recorded this.
Yeah, I'm happy to talk to anyone outside of this. Feel free to send me an email, give me a call. If you just have a random question and if I can send you on your right way without us being engaged, happy to do that. Of course, obviously, we're happy to be engaged, conflicts permitting as well, but definitely would like to be a resource for therapists and tech moving forward.
Thank you so much.